Lesson 2, Canadian Constitutional Law. What is a constitution? Constitutions are the guidelines of nations. They are the highest law of the land. Constitutions embody the values and goals of a nation. They are written to create the political and legal framework of a nation. They also include means by which they can be changed. But as the highest law of the land, changing a constitution should not be easy. The intent is that a constitution will provide order and stability to a nation. As you learned in this previous chapter, the Canadian Constitution Act of 1982 included the Canadian Charter of Rights and Freedoms, and this was the first written legal document of Canada becoming its own independent constitution. Constitutions are extremely important because they give order to a nation and ensure everybody is treated fairly and follows the same body of fundamental principles. In Canada, the Charter of Rights and Freedoms ensures everyone is treated fairly in their everyday life, as well as in court cases. Everyone is given the right to exercise and question their rights and freedoms listed in the Charter. Differences in race, religion, age, sex, gender, or disability do not affect how these rights and freedoms are applied. Whatever differentiates a person from another person does not matter. Everyone is the same under the Charter of Rights and Freedoms of Canada. As we already touched on in the previous chapter, different lawmaking powers are divided among the federal and provincial governments. Also, some laws are divided even more locally to municipal governments. The federal government is seated in Ottawa and is headed by the Governor-General of Canada on the advice of the Prime Minister. Its responsibilities and lawmaking powers include defense, criminal law, employment insurance, postal service, census, copyrights, trade regulation, external regulations, money and banking, transportation, citizenship, and Indian affairs. The provincial government's lawmaking powers include property and civil rights, administration of justice, education, natural resources and the environment, healthcare, and welfare. The municipal government, which is the government of smaller specified regions of a province or territorial government, lawmaking powers include the following: water, sewage, waste collection, public transit, land use planning, libraries, emergency services, animal control, and economic development. The division of legislative powers in court is done mainly by Sections 91 to 95 of the Constitution Act of 1867. A court emphasizes the opening words of Sections 91 and 92 particularly. These opening phrases use several concepts to create lawmaking power, the main ones of which are: lawmaking power is in relation to matters, matters come within classes of subjects are assigned by the Constitution Act 1867, and lawmaking powers are exclusive. These courts have built a method for dividing constitutional power out of this language and these four concepts. The method is now well settled. It is specific to Canadian federalism for two reasons. The language and the concepts used are specific to Canada's Constitution, and the balance of powers struck between the federal and provincial governments is uniquely Canadian balance responsive to Canada's urgencies. Now we can move on to the next section of studying the Canadian Charter of Rights and Freedoms and going through the specifics of the Charter and how it applies to citizens in Canada.